Good afternoon, and thank you for being here. Bon après-midi. I would like to begin by acknowledging that we are gathered on the traditional, unceded territory of the Algonquin peoples. C'est important pour moi d'être présent aujourd'hui en présence de mes collègues, l'Honorable Patty Hajdu, la ministre de la Santé, et l'Honorable Carla Qualtrough, ministre de l'Emploi, du Développement de la main-d'œuvre et de l'inclusion des personnes handicapées. Today we introduce proposed amendments to the Criminal Code's provisions on medical assistance in dying. The proposed legislation directly responds to the decision of the Quebec Superior Court in Truchon from last September. In this decision, the court found the existing requirement in the law that the death must be reasonably foreseeable in order to access MAID to be unconstitutional. The court gave the federal government 6 months to respond. The proposed changes also help address other issues that received considerable attention to the recent consultations with Canadians, during the recent consultations with Canadians. When we are talking about medical assistance in dying, we are talking about people who are suffering, families going through some of the most difficult times of their lives. So when it comes to these deeply personal and complex issues, we must act responsibly and, most importantly, with compassion. Along with my colleagues, Ministers Hajdu and Qualtrough, we have consulted practitioners, academics, and advocates at 10 roundtables held across the country. We also met directly with disability groups, Indigenous partners, and others with important insights into these critical questions. More than 300,000 Canadians provided their own views through online public consultations. This provided important direction to our work and demonstrated just how much our opinions, but also medical practice, have evolved in the past 4 years since medical assistance in dying was made available in Canada. Au cours des dernières semaines, nous avons tous mis la main à la pâte pour rencontrer les obligations de la Cour. La semaine dernière, en tant que procureur général du Canada, j'ai déposé une demande de prolongation de 4 mois à la Cour supérieure du Québec. Sans cette prorogation, le critère de prévisibilité raisonnable de la mort naturelle de la loi fédérale ne s'appliquera qu'au Québec, ne s'appliquera plus au Québec à compter de 12 mars, mais restera en vigueur ailleurs au pays. Aujourd'hui, nous avons déposé les amendements nécessaires pour répondre à la décision. Ces changements nous demandent un travail parlementaire important et nous devons prendre le temps de le faire. Une décision aussi importante chamboule nos valeurs et vient directement toucher nos sentiments les plus profonds. Les gens qui décident d'utiliser l'aide médicale à mourir vivent des souffrances inimaginables. Nous devons penser à l'impact sur la personne elle-même, mais également sur ses proches. La proposition que nous faisons aujourd'hui est importante. Nous devons être à l'écoute des besoins des citoyens. Today we have tabled new legislation that modifies the federal framework on medical assistance in dying. First and foremost, we have widened the eligibility to access medical assistance in dying. This responds directly to the Quebec Court's ruling. As a result of the change, we have created 2 tracks within the framework, one for patients whose natural deaths are reasonably foreseeable, and a second for those whose natural death is not. Under both tracks, patients must be faced with intolerable suffering and be in an advanced state of irreversible decline as the result of an incurable illness. Aujourd'hui, nous avons déposé un projet de loi qui modifie le cadre fédéral sur l'aide médicale à mourir. D'abord et avant tout, l'exigence selon laquelle la mort naturelle d'une personne doit être raisonnablement prévisible pour avoir accès à l'aide médicale à mourir n'est plus nécessaire. Ainsi, nous répondons directement à la décision de la Cour supérieure selon laquelle cette exigence n'était pas conforme à la Constitution. Nous proposons de créer 2 avenues, l'une pour des patients dont la mort est raisonnablement prévisible et l'autre pour ceux qui ne sont pas en fin de vie. Dans les 2 cas, les souffrances doivent être intolérables, le patient doit être atteint de malade incurable et son état de santé doit avoir atteint un stade irréversible. We have also said that we would listen to the stories on the ground and act where there is a clear consensus among the Canadian public. We know that there are patients who have met all the criteria to receive MAID, but who are not quite ready to go ahead with the procedure. Many are worried that they will lose access to MAID because they risk losing their capacity to give their final consent. Some have chosen to end their lives prematurely, sacrificing their chance to spend more time with their families, because this was the only way to guarantee that they could still have access to MAID. This was the story of Audrey Parker and others. No one should be faced with such an impossible choice. That's why we are introducing an amendment that will allow patients who are dying to choose to receive MAID even if they have lost their capacity to finally consent at the time of the procedure. To balance the proposed changes that we have made to the framework, we are also proposing new safeguards. I will let my colleague, Minister Hajdu, speak more fully to these measures. Nous faisons aujourd'hui un pas important. C'est une étape supplémentaire dans notre processus de réflexion commune. La réflexion n'est pas terminée. Nous allons continuer à étudier les différentes options qui vont émerger dans le futur. La révision parlementaire de la loi, qui devrait avoir lieu plus tard cette année, permettra de continuer à travailler sur ce sujet si important et sensible. Nous adressons aujourd'hui un enjeu qui touche directement les valeurs personnelles de chacun d'entre nous. En tant qu'élus, nous avons une responsabilité importante de s'assurer que nous accordons la liberté de choix aux Canadiens et Canadiennes, tout en protégeant ceux qui sont plus vulnérables. Je crois profondément que c'est ce que nous présentons aujourd'hui. Aucune décision que nous prenons ne devrait stigmatiser les gens qui ont fait un choix différent. I will now turn to my colleagues, Minister Hajdu and Minister Qualtrough, to say a few words. Thank you. Merci.
Well, thank you very much, Minister Lametti, and hello to everyone. Over the past few months, we've spent quite a bit of time listening to Canadians and asking what they thought about medical assistance in dying. And as Minister Lametti said, the feedback was extensive. I thank all of those people who participated and shared their views and often very deep personal stories. You've helped us shape the changes that we are proposing today. I also thank the opposition parties who have participated in the consultations. During these consultations, we heard strong support for a bill where some safeguards would be eased for persons who are dying. And we also heard strong support for legislation where additional safeguards would be put into place for people who are not dying, but who meet all the other requirements for medically assisted death. We believe the changes that we are proposing today will help address situations where the suffering of people already deemed eligible for MAID has been prolonged unnecessarily. At the same time, we think it is important, even while improving access, to ensure vulnerable individuals are protected. And that's why we're taking a two-tracked approach to medical assistance in dying. The first, where natural death is reasonably foreseeable, and the second, where it is not. As Minister Lametti said, reasonable foreseeability of natural death will no longer be a requirement for determining whether a person can access medical assistance in dying. However, it will still guide practitioners in determining which safeguards to apply. It is a very familiar concept for them after 4 years of providing the service. For those whose death is reasonably foreseeable, we would ease some of the pre-existing safeguards that we know have not served their purpose of protection. Under the current system, there is a requirement for a 10-day reflection period. We have heard that this safeguard does not provide additional certainty or protection. So we are proposing to eliminate this reflection period. For those who are at the end of life, the decision to request medical assistance in dying is well considered, and this additional period can prolong suffering unnecessarily. The current system also requires that 2 independent witnesses confirm that the person who has signed a request for MAID is who they claim to be and that no fraud has occurred, such as someone forging a signature. During our consultations, we heard that this requirement was a barrier for many people at the end of their life. Some might not know anyone outside of their family or their care providers. We've heard that this requirement definitely blocks access. As such, we propose requiring only one witness and allowing this witness to be a care provider. Those involved in assessing or providing MAID would continue to not be eligible as a witness. Now, for those whose death is not reasonably foreseeable, we would create a new set of safeguards. For example, there would be a minimum period of 90 days for assessing the MAID request. This period will allow for exploration, discussion, and consideration of options by the person seeking MAID with their practitioner. The legislation also requires that the person requesting MAID be provided with information on available counseling, mental health supports, disability supports, and palliative care to provide that informed consent. Now, on the waiver of final consent. Under the current legislation, those who lose capacity also lose their eligibility for medical assistance in dying because they must be capable of providing final consent immediately before the procedure. Practically speaking, this means that some individuals deemed eligible for MAID have chosen to end their lives earlier than they've wanted out of fear of losing the opportunity to receive the service. Others have refused to receive medication that relieves pain out of fear of losing their capacity. This is unreasonable and unjust. And that is why our government is proposing to include a waiver of final consent for people whose death is reasonably foreseeable and who have been assessed and approved to receive MAID. This means that individuals at the end of their life who risk losing their decision-making capacity before their chosen date, like Audrey Parker, would have an avenue to receive MAID without worrying about the possible loss of capacity. Support for this amendment is strong among Canadians and health practitioners. Dealing with other questions of advance requests is complex and raises important discussions that Canadians must have. The Council of Canadian Academies expert panel report on advance requests concluded that dealing with advance requests made by people who are at the early stages of an illness or who have not yet been diagnosed with any illness at all is very challenging. For that reason, these scenarios will be considered during the parliamentary review process slated to begin later this year. We've heard from Canadians, experts, healthcare providers, and stakeholders. And Canada has learned a lot from our experience with medical assistance in dying over the last 4 years. As society changes, so too must our laws to give Canadians the dignity they deserve at the end of their lives. Thank you.
Thank you. Hello, bonjour tout le monde. I'm honored to be here alongside my colleagues, Ministers Lametti and Minister Hajdu. Je tiens à remercier les Canadiens de nous avoir fait part de leur point de vue au cours des derniers mois. Il est évident que la question de l'aide médicale à mourir est très personnelle et sensible, et l'opinion des Canadiens continue d'évaluer à cet égard. From my perspective, as Minister responsible for disability inclusion, I'm working with my colleagues to ensure that the voices of persons with disability are heard. We also want to ensure that we don't do anything that in any way devalues the lives of or further stigmatizes persons with disabilities. Disability rights advocates have long fought for personal autonomy. Being able to make decisions about one's own life is fundamental. Les défenseurs des droits des personnes en situation de handicap luttent également pour l'égalité, car il n'y a pas une vie qui ait plus de valeur qu'une autre. Il existe de nombreux exemples dans notre histoire où l'autonomie individuelle et l'égalité de nos citoyens en situation de handicap ont été menacées, rejetées, ou ignoré. As we table these amendments to the federal MAID law, I want to be clear that we have carefully considered the input we received during our consultations. We have worked together to craft provisions that will balance making medical assistance in dying available without undue obstacles to those who choose it, with safeguards to ensure that this decision is truly informed and voluntary. For a truly progressive MAID law is one that recognizes, without compromise, the equality and autonomy rights of everyone. Mes collègues et moi-même poursuivrons notre conversation qui s'élargira au cours de notre prochain examen parlementaire. En tant que pays nous devons trouver une façon de progresser qui continue de reconnaître l'autonomie individuelle et de protéger les personnes vulnérables tout en tenant compte des objections de conscience. At the same time, we need to ensure that we do not further stigmatize or marginalize people who are elderly, ill, or who have some form of disability. I look forward to the next steps and to continuing to hear from Canadians on this important issue. Thank you. Merci.